Hi, my name is Kian, and today I will be talking about the contemporary relevance and accuracy of the ancient legal maxim, which is he who owns land owns everything reaching up to the very heavens and down to the very depths of the earth. The maxim dates back to the 13th century writings of Accursius and first appeared in English law is in the case of Beary and Pope in 1587, where it was used to illustrate a landowner's absolute ownership up to the heavens and down to the depths, although this idea has since been limited by modern law. So this maxim reminds us of three-dimensional nature of land ownership that has been long a fundamental principle in English land law. However, in an era of rapid technological advancement and increasing infrastructure needs, its literal application has been severely curtailed. The maxim is a powerful statement of absolute ownership. Historically, it provided a simple though somewhat idealistic framework for defining property. As noted by Yehuda Abramovich in his influential article regarding the maxims used in aviation law, he has been grievously misunderstood and misapplied. However, the law has for quite some time acknowledged that a literal interpretation is not practical or desirable. The court have determined that the maxim is no longer much of practical significance in its original absolute sense. The current approach focuses on pragmatism and balance, which aims to align private property's rights with public interest and technological demands. Contemporary academics like Laura Donahue have extensively analyzed this tension between private property rights and state sovereignty over airspace. My analysis will explore how judicial precedent and statutory intervention have redefined the vertical boundaries of a landowner's proprietary rights, focusing on both the airspace above and the subterranean space beneath. So now we're going to talk about the landowner's right above the airspace. The extent of a landowner's right in the airspace above their land is divided into two distinct categories. One is the lower stratum and the other is the upper stratum. This distinction has been extensively analyzed in academic literature regarding the modern application of the maxim. So in the lower stratum, the maxim retains some relevance. Trespass can be established where an object or structure intrudes into the space necessarily for the ordinary use and enjoyment of the land and its structures. The key authority here is the case of Kelson and Imperial Tobacco. In this case, the court granted an injunction compelling the removal of an advertising sign that only protruded a few inches into the claimant's airspace. This demonstrates that at a low level, the landowner's right to exclude is strong. However, the upper stratum is where the maxim is decisively rejected. The landmark case is Bernstein of Light and Skyviews. So Lord Griffith held that the landowner's rights only extend to such height as is necessary for the ordinary use and enjoyment of his land and the structures upon it. Above the height, the airspace is public. The court refused to grant an injunction against a company that flew over the claimant's land to take an aerial photograph. A literal application of ad colum would have made all air travel a trespass, which is clearly absurd. Scholars have long recognized this as the ad colum fable, which the myth that common law ever truly granted absolute airspace rights. For example, Michael Heller relates this fable as a story about lighthouse beams. His way of suggesting how absurd it would be if every landowner could sue in trespass whenever someone else emitted across his property photons from a lighthouse light. Heller uses the lighthouse beam as one of several case studies confirming the readers why it is wrong to see property ownership as fixed and unchanging. This recognition that property rights are not absolute is not just theoretical. The courts now have formalized limitation and reinforced by statute. For example, the Civil Aviation Act 1982, Section 76, Sub 1, provides that no action in trespass or nuisance can be brought in respect of the flight of an aircraft at a reasonable height. However, even with these statutory safeguards, new technologies such as drones raise fresh questions about the limit of airspace rights and the practical application of these principles. As covered under the Civil Aviation Act 1982 and the Air Navigation Order 29, drones are subject to strict flight restrictions, which typically require a safe distance of 50 to 150 meters from people or property and prohibit flights over restricted or controlled areas. The second part of this presentation will focus on the maxim ad inferos, which means down to the very depths of the earth. This principle has been historically treated with greater respect than the aspect related to the airspace. The common law generally recognized that the landowners possesses ownership of the soil, mineral, subsoil beneath their property, although there are also specific statutory exceptions for resources such as gold, silver, coal, and petroleum. This principle was tested and affirmed in the landmark case of subterranean ownership, which is the case of Bocado and Star Energy. Bocado is a modern case to consider how far beneath the surface of a landowner's title to land extends, and whether the landowners can sue for trespass for underground intervention into the subsoil or substrata. So the fact of this case is where the claimant, Bocado, owned an estate in Surrey, and the defendant, Star Energy, had a license to extract petroleum. So Star Energy drilled several wells that extended diagonally beneath Bocado's land at depths ranging from 800 to 2,900 feet without the landowner's knowledge or consent. So, and Bocado sued for trespass. As Callum Stacey notes in his detailed case comments, the drilling's existence did not affect Bocado's use or enjoyment of their land, yet the Supreme Court still found trespass. The core legal question was, did the landowner's proprietary right extend to the deep strata beneath their land, such the drilling constituted a trespass? The Supreme Court, led by Lord Hope, unanimously held that trespass has occurred. Lord Hope stated that the maxim case as solemn still applies to the subterranean space, albeit not indefinitely. He concluded that the landowner's title extended down to the point where the strata could be regarded as part of the land. Lord Hope states that the wells in question were not so deep to reach the point of absurdity, and the wells were at a depth where the strata could be worked for minerals. So they were clearly within the landowner's proprietary domain. Joe Morgan's comprehensive analysis of subterranean property rights confirmed that Bocado made clear that the surface owner of land also owns the strata beneath the surface. So in short, Bocado's case confirmed that at common law, the landowner's right extend to a considerable depth, and the drilling can be constituted as trespass. The court upheld the ad inferos principle, illustrating its persistent relevance in safeguarding private property rights against commercial misuse. Although the Bocado decision reaffirmed common law property rights, it also created major challenges for the energy industry, particularly for practices such as hydraulic fracturing, or commonly referred as fracking. Since these activities require drilling deep underground for national energy projects, the ruling quickly led to a new legislation to make such operation easier and more practical. As Evelyn Chews observed, these statutory changes represent a significant departure from the pre-existing law, particularly in respect of subterranean land use. Under the Infrastructure Act 2015, Section 43 to 48 are the provisions that override the common law position established in Bocado. Section 43 grants a statutory right to use deep level land for the purpose of exploiting petroleum or deep geothermal energy. The term deep level land is defined as a land at a depth of at least 300 meters below the surface. Besides, the right is granted without the need of the landowner's consent. So the Act removes the right to claim trespass or nuisance for the use of this deep level land. As we know, The case Bocado is crucial because it provided a clear common law baseline for subterranean rights, which prioritized national energy interests over the absolute proprietary rights of the individual landowners below 300 meters. However, its immediate legislative reversal, enacted by the Infrastructure Act 2015, represents a fundamental statutory limitation on the ad inferos maxim. This legislative intervention demonstrates the conflict between private property rights and the demands of the public policy within current land law, and this situation prompted Parliament to officially redefine the ad inferos boundaries. So, what is the contemporary relevance and accuracy of this maxim? The maxim is fundamentally inaccurate if taken literally because it is no longer a statement of absolute right, but rather a rebuttable presumption that has been significantly eroded by both the judiciary and the parliament. At common law, landowners were once considered to have absolute ownership of the airspace above their land extending to the heavens. However, this position has been limited through judicial interpretation, particularly in Bernstein and Skyviews, which held that ownership only extends to the height necessary for the ordinary use and enjoyment of the land. Therefore, the maxim ad column is no longer entirely accurate, as it now applies only to the lower stratum of the airspace, as seen in Kelson and Imperial Tobacco. Similarly, under the ad inferos aspect, Star Energy and Bocado confirm that land ownership extends to a significant depth beneath the surface. Yet, this principle has also been limited by statute, such as the Infrastructure Act 2015, which allows certain underground works and energy exploitation below 300 meters without the landowner's consent. Consequently, the ad inferos principle is also not fully accurate today, as statutory law has restricted the depth to which ownership practically extends. In conclusion, the Lati maxim is limited in today's society, as ownership of the ground or the air cannot extend indefinitely. There's no express law stating an exact cutoff point in either direction, but rather an application of necessity and reasonableness. So this is the end of my presentation. Thank you.